Good evening, Young Kings. Time for your morning motivation. Time to get started on this new endeavor, this new journey in my life. Um, been feeling pretty good. I think the anticipation um, was a lot worse than the actual reality of receiving the divorce papers. So, the anticipation, I know when I found out that um, my wife had filed, I used to come home from work and wondering if this was going to be the day that I got the papers in the mail, and just that anxiety about what is happening. And it was about 2 weeks from the time that she filed to the time that I actually got the papers. So that anxiety was creeping in each day I came home trying to figure it out. But now that I actually have it, the papers here, um, it's less than what the reality of it is. Like it's accepting. I'm accepting this reality. So um, I guess that's a mental, a motivational tip in itself. Is like don't let anticipation of an event um, hurt you or distract you. Meaning like what's going to happen will happen. What will be will be. So I think in my mind, I was creating scenarios like, hey, when I get it, I'm going to feel bad. I'm going to have all these anxieties. It's going to be a bad day. My mind started planting seeds of that, and it's telling me like, wow, do you check the mail today? And the reality of it is, it's like it was just like a regular day. I got it, and now you got to deal with it. So get on into the motivation. I did go to the gym this morning. Um, and there's a saying out there: don't ask God for the easy life. Um, Ask God for strength to endure a hard one. So did some bench presses today. Put some extra plates on the bar because during this process you got to lift some heavy shit. So you got to get stronger. And that's the process here is for me to get stronger and for me to start learning to navigate through this new season in my life. So I am going to go through some of the things today with my attorney, and I figure we might as well have you come and participate while I go through that, so you can be aware. As I said, I want to be fully transparent in this process. So when I meet with my attorney, I do want you all there so you can see what we're talking about and what we're discussing. Um, the wife did call me the other day. It was kind of weird. Like, the last um, 6, 7, 8, 9 months been trying to have conversations, and obviously I've been blocked, and all of a sudden attorneys and I get a call, so I didn't answer it. Um, but those who are watching and then reporting back, just let her know that probably have her attorney contact my attorney, and we can talk through the legal speak from that time, because when it was cordial and trying to go through that, it was on deaf ears, and so it was no use, or it was not productive having those conversations. So I'll just talk from attorney to attorney. So during this process, I realized like there's going to be a difference point of view. Let me get some light because it's going to shed some light on this situation. Let me see if I can get see if that was, oh yeah, that's a little better. Shed some light on the situation. So there's maybe some confusion as I go through this, the duplicity of the personalities that I have going through this. So I was trying to figure out, how do I separate my client from the attorney, and trying to figure that out. So I think I got it. So this is what we're going to do. When I'm transitioning to the attorney, then I think we'll have him represent with my glasses. So this is attorney Drew. This is defendant Drew. So we'll go through that process and we'll navigate through it. Plus, I'm gonna have to read a lot, so I figure I better have my glasses on to read through this. So without further ado, I know it was kind of a long introduction, 5 minutes. There's a lot to unpack here. So I might break this up depending on how long we get. We'll see how far we get into this. So according to the document that was submitted for filing in the circuit court, they came up to a case that they wanted to reference, and it was the Kretzschmar versus Kretzschmar 48, Michigan, application 279, 210, and it's NW2D 353, dated for 1973. The Kretzschmar versus Kretzschmar, and so I went and pulled it and I looked it up, and it's from the Michigan Circuit Court of Appeals, filed July 13th, 1973, and that's 2 years before I was born. The citations, as I mentioned, is 210. Looks like NW2D 35248 Michigan application 279, and that's kind of what's stated here. So I'm not sure if you can see that in this document. Let's see if I can get it on camera. I don't know if you can be able to read that. Probably won't, but just take my word for it. That's the statute that they were filing the basis of their divorce on. So, looking at this, Kretzschmar versus Kretzschmar, and as I was studying this case, I realized there's some discrepancies in the application of this when they tried to apply it for my case in particular. The first discrepancy is that the Kretzschmar versus Kretzschmar is like the husband in this case was divorcing the wife, and then in our case, the wife is divorcing the husband. So that's the first diversity of the two trains of thought between this what took place back in 1973 and what we're doing in 2020. So I am the defendant in this case as the husband. In this case, the husband was the plaintiff. He was the one initiating the divorce. So that's the first discrepancy on there. So we're going to read through this, and we'll stop here and there for a few pieces and go through how we deduct this and go through this whole process. So it starts with the plaintiff appeals for dismissal of his complaint for absolute divorce from the defendant. The plaintiff and the defendant were married in 1944. Wow. All right. They had 3 living children, and one who was a minor residing with her parents at the time of the trial. Well, and that's right there is another discrepancy. We got 4 kids, and none are minors. They're all over 18. So I'm struggling to find the application. Hopefully, it will come more clear down the line. The plaintiff, which is the husband, filed an amendment complaint seeking divorce under 1971 PA 75 MCL 552.6 MSA 25.86. I guess that's the lawyers speak. That's how they list their laws. The defendant, which is the wife in this case, filed a counterclaim seeking separation maintenance under 1971 PA 75 MCA 552.7 MSA 22.87. So it looks like in this first paragraph, the husband filed for divorce, and then the wife came back and filed a counterclaim asking for separation maintenance. So kind of like spousal support or alimony is what it would be called in today's legal speak. So the husband is the initiator, the wife is the respondent. In our case, the wife is the initiator and the husband is the defendant / respondent to this on this case. So going on to the second piece, it's like Dr. Kretzschmar, so he's a doctor, he's a professional individual. I see where the relation coming up because I'm a professional too. I consider myself a professional, so I guess that is kind of related. Dr. Kretzschmar, and I may be butchering his name, but just forgive me. At times I can be functionally illiterate. I'm brilliant, but at times it struggles to come out. Dr. Kretzschmar, the plaintiff, testifies that the marital difficulties commenced in 1957. Hold up. And that's where I want to pause at, because they got married in 1944, but they didn't start having problems until 13 years later in 1957. And I think that's a divergent in what I experienced, because it looks like they enjoyed 13 years of good marriage, because like from 1944 to 1957, when the husband who's filing saying that that's when their difficulties started. Let me talk to my client. Now, when it comes to me, our difficulty started immediately. We got married June 16th, 1995. I know you got it wrong in the document. It said June 15th, but it was actually June 16th. We got married June 16th, 1995. Right after our little honeymoon thing, which wasn't much because I was a private in the Army, so I didn't have much. She refused to relocate with me down to my duty station in Georgia, down at Fort Stewart, Georgia. So I didn't enjoy 13 years of a marriage, of building a relationship before it started to deteriorate. Um, After my marriage, it took me 5 years before I got to live in the same place as my wife. 5 years. Three down in Georgia, and then I got a scholarship to go to college, and she refused to relocate with me to college. So the first 5 years of our marriage, I was abandoned. And yes, I did some inappropriate stuff during that 5 years. I did cheat, and I should have been more morally strong in being able to withdraw from that. But um, that's not the same as in this case. They enjoyed 13 years from 1944 to 1957. That's when he says that the um, difficulties started to happen. So I already see there's some discrepancies between this case. So let's continue. Dr. Kretzschmar, the plaintiff, testifies the marital difficulties commenced in 1957 when he, along with his sister, inherited private hospital into a nursing home, and the plaintiff gave up his general medical practice. So it looks like here he was a doctor and he had a vision to do something, and he surrendered his practice to go convert an old hospital into a nursing home. The defendant, which is the wife, criticized John A. Callahan, the plaintiff's sister, husband, and plaintiff's business partner regarding his management of the nursing home enterprise. The plaintiff, which is the husband, testifies that although he regarded Mr. Callahan as an extremely able businessman, the defendant, the wife, accused Callahan of being incompetent, untrustworthy, and a sharpie. And I don't know what a sharpie is. Maybe that's the slang back then for a dummy or something like that in the 1957. According to the plaintiff, the defendant believed that Callahan was unnecessary and that the plaintiff could manage the business without him. So the wife, on this hand, didn't want his business partner to be involved in the business. She thought he was incompetent and a sharpie, whatever that means. Somebody know what sharpie is? Put it down in there. So that's where their division started to happen. The defendant also allegedly accused the plaintiff of being stupid, lazy, inefficient, and indolent. So the wife, this is what she accused her husband of being: stupid, lazy, inefficient, and indolent. I can say that those are probably pretty accurate. I don't think she could be able to call me lazy, but stupid, inefficient, yeah. I don't even know what indolent is. Maybe I have to look that up, increase my vocabulary. But yeah, there's been several accusations of indictments against my character on here. So I can see where you felt like his wife felt about him. So I guess that is a correlation between that. But let's continue. The plaintiff further testified that the marital arguments and conflicts continued throughout the 60s, during which time the defendant allegedly called him mentally incompetent, suggested he had a stroke, and that he described him as a drug addict and an abortionist. Meaning, like, wow. So she was accusing him of being mentally incompetent, suggested he had a stroke, and described him as a drug addict with an abortionist. And then it says accusations were reportedly made in the presence of their children to a third person. So there's a lot of insults going on, and I can attest to that. I mean, and recently I know I was called, and this is one part that I won't shy away from. We both have called each other various different names and stuff of that nature. So I think we're both guilty of this and that aspect of it. So I won't try to point like it was just you calling me this, but there was a lot of back and forth. So maybe that applies or whatever. The next paragraph goes, how long are we in? We still got some time. We can continue to build on this. Dr. Kurtzman stated that during a heated argument in a marital home in 1969, the defendant clawed him with her fingernails, and he reportedly he responded by spanking her. How do you spank someone? Like he gave him a whooping? That's not funny. Whatever. But subsequent to the incident, the plaintiff spent a little time at the marital home and moved out completely in early 1970. He admitted that in 1969 he saw another woman 2 or 3 times a week, spent money on her, and refused to give up his association. I'm guilty of that. I already admitted that I've committed adultery, so I guess that's where there is a connection between that. Um, but the I see, and you're gonna find out later. Like this, there's a departure and there's a theme in here. Like there's accusation. No, I won't even give you a pre-reading. We'll just get to it. But um, he alleged that the woman clawed him with her fingernails and responded. And I told you a while back, um, I did go to jail, but there were some trumped up charges that was thrown out. Like I did break a TV and tore up a painting, but she she misrepresented what I did, and I ended up going to spend a night in jail. And the judge threw it all out. I mean, he didn't even see me. He said, "There's no grounds for anything here. You didn't break the law. There's nothing of that." So, but there are incidents where she has done the same, or actually hit me. One, I got it on video, so I might show that video to my lawyer if I need to have proof for that. But also, like the painting I tore up, there's incident where she came to my house um, and tore up a painting in my house when I was in my loft before I moved over here. So it ain't just been one way, and I think that this is where this case is kind of it's misleading because, and I'm gonna have to call him out on that. Now going to this next paragraph, it talks about Mrs. Kretzschmar, which is the wife. She's the defendant in this. Testified that the plaintiff had been physically violent on numerous occasions. And when I read that, I was like, oh, okay, that doesn't apply to us. I haven't put my hand on her in a non-violent way. Now, I'm not excusing the fact that, excuse me, the duplicity of it. Sometimes I get caught. I'm not excusing the fact that it was okay for me to break a TV or that, but that's all material things. This case is alleging like there's been physical violence on numerous occasions. Um, so if you're using this case as a citation, this is an inappropriate application of what we're going through because this is not our story. This has not been. I've never been in a domestic violence, and I know some may say that tearing up a TV is a form of it, but I paid for it. And then as soon as I got out of jail, the same day I got out of jail, I went and bought a new one. And I know that doesn't exempt me from the fact that I shouldn't have done it in the first place. But I started um, to reconcile that and try to repair it. When my property was damaged, it was nothing. It was just like, oh, it's different. The only thing different in the case, and this is what I told her the other day before we got into this legal battle, I said the only thing different between what I did and what you did is that I didn't call the police and put you in jail. When she actually tore up my painting and kicked me and all that stuff, I could have been malicious and called the police, and that's the only difference. And the difference is that when you did it, I was like, okay, she's just mad and this and that. But when I did it, that's when the police was called. So, but I guess that's the way it is. Let's continue. So Mrs. Kretzschmar testified that the plaintiffs had been physically violent on numerous occasions. She stated that at the time, let me rephrase that. She stated that at the time of the August 69 altercation, the plaintiff arrived home intoxicated, and when she attempted to dissuade him from leaving to visit another woman, he knocked her down and abused her physically and verbally. Um, First of all, when my incident happened, I was sober. I was just getting out of work. I probably was in a bad state to come there. Excuse me, bad state to come there because I was getting out of work and I was on the phone with my daughter, who's told me that you're down in Detroit seeing another dude. So yes, I mean I was probably have an emotional trauma. That's no excuse, but I wasn't in an altered state. I was just getting out of work, and I was planning on going home. And then, when that happened, I came to say, "Hey, what are we doing? Are you dating someone? Do you want to? What do you want to do?" So she's saying that he knocked her down, he abused her, physically and verbally. I said some things about you dating for free down there, and are you gonna? Is he paying bills? And I said some derogatory stuff, so I'm not gonna act like there was no verbal abuse there because there was some profanity used in regards to you choosing to take that route. Um, Anyways, let's continue on. The defendant stated that the plaintiff admitted that the plaintiff had spent considerable amount of time away from the home without telling the defendant where he was. So she's saying this guy is just picking up and he's leaving the house and he didn't go anywhere. He didn't tell her where he was going. That's not the case with me. That's not the case. It's like um, I didn't spend a night from that. Once we started dwelling together, unless I was out of town on work, I wasn't leaving the house and just going places and staying a considerable amount of time. I was work from home. I was working, an hour and a half from home. So I spent like 3 hours on the road. I might have stopped by a happy hour or stuff, but that's not in line with what we're going through. So I'm still struggling to figure out how this is the basis of our divorce based on this case. So we're going to continue on. Let's continue on. Um, the plaintiff sometimes came home intoxicated, and then and that he struck the defendant and called her obscene names. Once again, see, that's a slippery slope. They're trying to throw these implications on with these cases. If you just read through the document that was sent here and says that's what they want to file based off that, and you just go in there and you didn't read the case in which they're filing against, they can start throwing all these accusations and you become guilty just because you didn't understand what was in that case. No, this is I've never been an alcoholic coming home abusing the wife. So if you're going to use this is a false application of this case, and y'all gonna have to go back to the drawing board because this is not lining up. Um, let's continue on. This is the because after that, let's say this. I'm gonna go back and read that sentence. The defendant stated that the plaintiff admitted that the plaintiff spent a considerable amount of time away from home without telling the defendant where he was. The plaintiff sometimes came home intoxicated and that he struck the defendant and called her obscene names. Ms. Kretzschmar denies any wrongdoing on her part. And I think this is one of the most applicable lines in this whole case. Ms. Kretzschmar denied any wrongdoing on her part. And I think that's probably what y'all can build your case on because according to her, I was the only one that did something wrong. Like there's nothing in this thing that she can say that she participated wrong. Or if she does, it's like, oh yeah, but that was just minor. Yeah, I tore up his painting, but I didn't go to jail. I didn't do that. It's like so. If you're going to draw on something, I recommend that y'all use that as your opening statement. Ms. Morton denies any wrongdoing on her part, and I think that should be your defense because the rest of the stuff is not applicable. But let's continue on. Um, the defendant related that the plaintiff's personality had changed drastically for the worse during the period in question, just leaving her to believe that he was mentally incompetent. I've been called incompetent. There's been statements made like you just like your dad. The apple don't fall too far for the tree. Um, you're an asshole. There's been some statements in reference to my mental um, competency. So I think you're kind of relating to how this lady felt about her husband, is kind of relating to how you felt about me. Um, the plaintiff alleged excessive use of amphetamines to prompt the defendant um, description of him as a drug addict. Hmm. So this case is built on a man that is an alcoholic, drug addict, and domestic violence, known to be domestic violence, beating and stuff like that. This this is an assault on my character and everything because I've never done that. So yeah, we're gonna have to. You're gonna have to go find another way to articulate why you want a divorce. First of all, I'll leave that alone. That's more attorney speak. Michigan is a no fault state. You don't need a reason to divorce me. You can just say I don't want to do this no more. But the reality of it is, it's like you need to just go through that process and just leave then. Don't just go through and just try to act like you're doing something. So um, I don't know. We're going up on 25 minutes, but this is the last thing. At the time of the trial, parties had not lived together for over 2 years. And since I've been back from Africa, we haven't really dwelled, and that's been about 2 years. The defendant contends that the marriage can be saved and is willing to consult a marriage counselor for further reconciliation. That's not your case. You don't think we can be saved. The plaintiff refused to seek marriage or counseling. I've actually asked for marital counseling, and you said no. There's times I came over and been praying for us, and you told me to stop praying. Like, there's no hope for us. So, we'll continue this on another day, but let me take a break because I want to dive into this more, and I'll come back probably tomorrow and we'll finish out the rest of it. But, Young Kings, don't ever just sign nothing. When you get a contract or something, don't ever just sign nothing and just put your name to that and say, okay, let's get this over with. Read the fine print. You got to be a young king. You got to read. You got to know what they're saying and what they're saying in there. So y'all have a great day, young kings.